Welcome to All Things Financial with Jack Driscoll. Each week, Jack takes on all things you thought were hard to understand about your finances and makes it fun, easy, but most of all interesting. From insurance to the best way to save your money and squeeze the most out of the dollars you put aside for your rainy day. And now, you have a friend in the money business. Here's your host, Jack Driscoll.
Welcome back again, everyone, to another edition of All Things Financial. As you know, I do this show on as many of the areas as I can think of regarding financial planning and all things financial, including taxes and insurance and saving for retirement, things like that. So what I wanted to do over the last couple weeks, you noticed we've had a special guest on the show. And Tammy, I'd like to welcome you back again.
Thank you, Jack. Good
Appreciate
to be here.
your coming.
Sure, glad to be here.
And what we have been going over is this process of if something happens with legal and tax issues in the event of death, probate, wills, how to handle those and what's all involved. So Tammy, I appreciate your coming back on the show.
Sure.
Maybe we can get into some questions on what is all involved and what about these taxes and the onerous probate and what are the costs and things like that, if you don't mind.
Sure. So with probate, the last time I was here, we talked more or less about the process involved, and there are costs that are associated with probate. Some of them are costs that are strictly probate-related costs, and some are costs that people will incur regardless of whether you have a probate estate or if you die without any probate assets.
Okay.
So some of the strictly probate costs there are fees that you have to pay to the Register of Wills and the Orphans Court. Essentially, they're administrative type fees because you're paying them to perform their job function and do a service. So you open an estate, there's a cost to do that. Generally, it's $200 to $300 when you open an estate. So you go to the Register of Wills and you go through the process that we discussed the last time I was here, and then they charge you a fee, and that's generally in the vicinity of $200 to $300. You also have advertising costs. That's another step of probate, and it costs roughly $100 per newspaper, and there's a minimum requirement of 2 newspapers, so you're looking at another $200 for that. And then at the end of the probate process, there are additional fees that you have to pay when you file the inventory, when you file the status report and the closing documentation. The inventory cost fluctuates depending on the size of the probate estate. So if you have a small estate, if you have only $100,000 worth of assets, bank accounts or a car or what have you, then your probate fees, your administrative fees for the inventory filing will be significantly less. If you have a large estate, $1 million or something, then your costs will be significantly higher. And it's a scale that the Register of Wills has set forth, and you just determine what that cost is depending on the actual size of the probate estate.
What happens if, when you say small estate versus large estate, if it's so small, there's very little inventory list or whatever, what happens there?
Right. There is a procedure called a small estates distribution procedure, which allows you to go through an abbreviated probate process. There are still some costs involved because there still are some steps involved.
Okay.
It shortens the procedure a little bit and it simplifies things a little bit. Most attorneys don't find it to be a significant savings just because there are still enough procedural type things that have to be done that you're still going to incur some of those costs.
Is there any chance when the executor, executrix goes to their attorney and says, this estate has to go through that whole process of probate for only this asset or only these? Is there any limit where they say, okay, we won't make you go through the process?
The small estates petition limit is $25,000, and there are a few specific types of assets that sometimes can be distributed without going through any process. One of the things is if you have a small bank account, and it's generally under $10,000, I believe, if you haven't paid funeral costs, then the bank will write a check directly to the funeral home to pay the funeral costs. So there are a few minor exceptions like that, that on very, very small estates, sometimes you're able to avoid the probate process.
But otherwise, we have the inventory list, and the cost will depend on the size of the inventory list.
Right. So, those are typically the true costs associated with the probate process. Then you're going to have attorney's fees, and some attorneys charge as a percentage of the size of the estate. I generally charge as a just straight hourly fee. Most of my clients prefer that because they feel that I'm being compensated for the work that I'm performing, and I'm not getting a windfall if they happen to have a large estate. So but again, if somebody wants to do the percentage method, that's a sliding scale between 7% and 1%. So it averages out probably to about 5%. So if you work with an attorney who's going to charge fees based on the percentage, it's usually going to be 5%, around 5%. So those are more or less the costs. The other major, I guess, issue related with probate is the tax aspect of it. When we're living, we all pay income taxes. So we all know our federal 1040, and if you live in Pennsylvania, your PA 40. So when you die, your estate becomes a legal entity. So as a legal entity, it's also a taxpayer. So the estate can incur income taxes. If the person who died also had a trust, the trust is a separate legal entity, and the trust would also have an income tax return. So depending on how the person's estate was designed, you could have an estate income tax return, both federal and Pennsylvania, that you would have to file, and you may also have a trust income tax return if the person had a trust as well, which would also be federal and state. So you're looking at a federal and state income tax return for the estate, possibly for the trust, and then there's also the death taxes, which are in addition to any income taxes that you would have. Yeah, so it can get to be rather complicated depending on what the assets are, how much income is being generated, if you have multiple entities and things like that.
Do they all get paid at the same time, or when do they all get paid, and how are they?
Well, that's a good question. So the inheritance tax, so the death taxes, there's the federal estate tax and the Pennsylvania inheritance tax. Those are your two death taxes as a Pennsylvania resident. The inheritance tax and the federal estate tax are due 9 months after date of death. So depending on when somebody died, you calculate out 9 months, and that's the deadline for the inheritance tax and the federal estate tax. So if somebody died on January 2nd, their federal estate tax would be due on October 2nd, so that's 9 months later. The income taxes are due when people's income taxes are due. So an income tax return for an estate or an income tax return for a trust is going to be due on April 15th, just like yours, your 1040 and my 1040. Now, both of those can be extended. The federal returns and the income tax returns and the estate tax returns can be extended. There's a 6 months extension period for both.
So that's just like normal also. Income taxes.
Yeah. And with the inheritance tax or the federal estate tax, it's a one-time only extension, which is pretty much true for income taxes as well. If you don't get the taxes paid by the original deadline, you have additional 6 months to pay it. And beyond that, you can file late, but you're in trouble. Right.
What about the inheritance tax? Are they different rates? And what about the estate tax? Are they different rates, or are they all the same for everybody?
Right. Well, the federal estate tax return is the one that people are most concerned with because it's a lot of money. The federal estate tax rates, if you're subject to that tax, can go up to 50 or 55%. So that's a
50
very
or 55% of what?
of the value of your assets at the time of your death.
Okay.
Okay.
Half.
Essentially half.
Might be.
Right.
Yeah. Okay.
Now, the federal estate tax has gone through a lot of change in the past 10, 15, 20 years. Initially, if you had a gross estate over $600,000 when you died, you started to pay federal estate tax. And at that time, it happened to be 37% was the initial rate that you paid.
Okay.
Now, they've increased the exemption so that it's approximately $4.5 million. So most
5.4 million.
million, right?
5.4
million.
Yeah.
So
I think it's 5.45 or
something
whatever now,
yeah.
something like
It
that.
keeps being adjusted for inflation, so
Right.
every year it's going to
Right.
go up. So most people don't pay that anymore. There are very few people who die with gross estates in excess of $5.4 million.
What if you're married?
Your spouse has also a similar exemption amount. So between a married couple, if it's a 5.4 million exemption, the two people combined would have 10.8 million before they have to pay any federal state taxes.
Okay.
So with such a large exemption, the federal state tax return and those taxes, even though it can go up to 50% tax rate, it's not paid by very many people.
Yeah.
You know, you have to have quite
That's
a
a
large
lot.
estate
Yeah.
to be able to be in a position where that's a tax that you're going to be paying.
Okay.
So for most Pennsylvania residents, we're looking at the Pennsylvania inheritance tax return.
Now, before we get to the Pennsylvania inheritance tax return, on the federal estate tax, if you're married, you have the double exemption.
Right.
What about if one of the spouses dies? Does the other spouse owe estate tax?
Right. Okay, so the estate tax is paid on the assets that the decedent owned in his or her name.
Okay.
There's a deduction known as the unlimited marital deduction. So if you and I were married and I died first, if we had a joint bank account, half of it is mine, half of it is yours, but for federal estate tax purposes, the half that was mine goes to you at a 0% tax rate because we were married, and as a spouse, you are inheriting my asset at 0% tax.
At any amount?
There's no limit on the marital deduction.
Okay.
Okay, so if I have a will and I say everything goes to my husband, and I could have a $30 million estate,
Okay.
and if I give everything to my husband,
Right.
then he pays 0 federal state taxes.
Okay.
Now, when he dies, he's going to pay, or his estate's going to pay tax on the $30 million he got from me,
Okay.
plus however many million he had. So his estate then at that time would be paying tax. So
Okay.
it's not that the government's not getting the money, it's just that the tax is being deferred.
Okay.
And they pay it at the death of the second person if everything went to the spouse. Now, if I have a $30 million estate and instead of giving it to my husband, pretend he's got $50 million and I know he doesn't need any more, then I would give all of my assets to my children, and they then would be paying the federal state tax on the $30 million that I give to them. Subtract out that $5 million deduction that we talked about earlier, the exemption of $5.4 million. So then they'd be looking at tax on the excess of that.
Okay.
So no, there's not a limit on the marital deduction between husband and wife.
Okay.
Okay. The other thing with the federal estate taxes is that if the first spouse to die doesn't have enough assets to use their entire $5.4 million, and again, that number is going to be indexed for inflation. So next year that number will be higher, and the year after that number will be higher yet. But if the first spouse to die doesn't have enough assets that they fully utilize that exemption amount, the surviving spouse can claim, it's called portability, and you claim that you're using the unused portion of the first spouse's exemption.
Ah, okay. I've heard of that.
Right, so portability, it's a fairly new concept. It's only been around for a few years. Before that, each person had their own exemption amount, and if you died and didn't use it up, the excess was wasted.
Okay.
So back in the days when the exemption was $1 million, if I die first and I have $800,000 in my name, but my exemption is worth $1 million,
Right.
there's $200,000 that's wasted. But now under the new law with the portability, if my husband elects the portability, then he would get my extra. In my example, it would be an extra $200,000. So
Right.
when he dies, he has his full exemption, which who knows, that might be $5.4 million. It could be up to $6 million by then. It doesn't
Or down
matter.
to one.
Or down
Who
to one,
knows?
right? But then he would get the $200,000 that I didn't use whenever I died. So that can be something that people that have significant assets, they don't have to title everything 50-50 between husband and wife. They can know that between the two of them, they're going to get the full exemption
Okay,
amount.
that's good.
Right.
And the reason I say down to one, folks, is the laws have changed, as you know, Tammy,
many
where
times.
it was 600,000 maximum limit per person, and then 1 million, and then it went up, what, to 2, I think, up 100,000 a year or
Right.
whatever over a 10-year period. And then I don't remember what year it
2010.
was. 2010. There was a year with a gap where
No
it was
taxes.
zero, no federal
No
estate
federal
tax. And then it came back at like 5.45 so 5.34, I think it started, whatever it was. But now, laws couldn't change.
Right. Oh, they can change.
So when we look at
Right.
planning,
Right.
and we have an inflation increase right now,
Right.
that's not to say they can't pull the rug out
Right.
from under
That's right.
us someday, and it's
Right.
been on the table.
Oh, it's always on the table. It's a very political issue.
Yeah.
And I personally think that the best planning is to try to have close to equal estates between the husband and the wife. If they take the portability away, which, as I said, we've only had that for a few years. So if they decide to take it away, now you're back into the position where whoever dies first only gets exemption on their assets.
Yeah.
So the people who have all of the assets in the name of one spouse, if the spouses die in the, quote, wrong order, then they could be looking at a lot of taxes if portability is removed.
Okay.
Or if you haven't elected portability. That's the other thing. There is an affirmative action that has to be performed when the first spouse dies in order to claim the portability.
Okay.
And which that is to file the federal state tax return, because most people who die with a federal estate or with a gross estate less than $5.4 million don't want to file the federal state tax return because there's cost involved with doing that.
Yeah.
You have to pay a lawyer or a CPA to prepare the federal state tax return, and that takes gathering information and compiling the numbers and double checking everything. So sometimes people say, well, I'm below the limit, I don't want to pay to have the federal state tax prepared and filed. But that's the only way you can elect portability.
I see.
So they're tied together. If you don't file the federal state tax when the first spouse dies and you have to affirmatively elect the portability on that return, then the second spouse has lost that option to claim the unused portion from the first spouse.
Okay. And then now to the Pennsylvania, if you're living in Pennsylvania,
Right.
inheritance tax, everybody, as a rule then,
Right.
might have to
Right.
incur that tax,
Right,
right?
right.
Is that the recipient, based on the recipient of where they live in the country, or is it based on the decedent?
So the inheritance tax return does not have an exemption amount. So for Pennsylvania purposes, if you die with an asset equal to $1, you will pay Pennsylvania inheritance tax on your $1 asset.
Wow.
Okay. So we talked about the federal having a $5.4 million exemption, and
Okay.
Pennsylvania has none. So pretty much anyone who dies in the state of Pennsylvania will pay will pay Pennsylvania inheritance taxes. However, there's a similar marital deduction as there is in the federal program. It's slightly different technically, but the end result is more or less the same. So
Okay.
again, between husband and wife, whoever dies first, if that person transfers all of their assets to their surviving spouse, either by their will or their trust, or if they were jointly titled, then the surviving spouse pays 0% inheritance tax. So technically you are paying inheritance tax, but it's a 0% tax rate, so the end result is no tax.
Okay.
Okay. So that's one way to avoid Pennsylvania inheritance taxes. The only other way is to die with no assets.
Okay.
So essentially, 99% of the people who die in Pennsylvania, unless you have a surviving spouse who's going to inherit everything, will pay some Pennsylvania inheritance taxes. And the tax rate for Pennsylvania is based on who the beneficiary is and how that person is related to the decedent.
Okay.
Okay? So for income taxes and federal estate taxes, we're used to having just a flat rate. You know, your income taxes are assessed based on the amount of income you have.
Right.
So whether you're at the 28% or the 20% capital gains or 35% or whatever the tax rate is, it's based on the value of your income. But for Pennsylvania inheritance taxes, the tax rate is dependent on how the beneficiary is related to the decedent.
Okay.
So I already said that the spouse gets a 0% tax rate. Children, grandchildren, great-grandchildren, any lineal descendant is taxed at 4.5%.
Okay.
The siblings, if there are siblings of the decedent, and if they are beneficiaries under the will, those people are taxed at 12%.
Brothers, sisters.
Brothers and sisters.
Yeah. Mm-hmm.
And anyone else is taxed at 15%. So that could include nieces and nephews and friends and neighbors and things like that.
Okay.
Charities, again, are 0 because that's the same as on your income tax return. You get a charitable deduction for that. So for Pennsylvania inheritance tax purposes, you don't essentially get a deduction, but you pay 0% tax on the amount that's going to the charity.
Okay. And that tax, if you live in Texas
Right.
and the decedent's in Pennsylvania,
Right.
does Pennsylvania charge the whole estate Pennsylvania inheritance tax regardless of the
Yes.
country or the
Right.
state of residence?
Right.
Okay.
Because the tax is based on the decedent. So the decedent died as a Pennsylvania resident,
Okay.
and then where the people live is irrelevant when you're filing the Pennsylvania inheritance tax return. The only thing that you have to be concerned with is the relationship between
Okay.
the decedent and the beneficiary.
So it's expensive to die. Don't die, everybody.
Well, it depends, again, who your beneficiaries are. People who leave everything to their spouse, they're not paying any tax. People who are very charitably inclined, they're not paying any tax. And if you're paying tax to your children or your grandchildren, 4.5% tax is really not a significant tax compared to some other things. You know, I've had conversations with people where we've tried to be doing some tax planning because there are things involved with the tax law that are known as a step-up in basis. So if I give an asset to you, then your cost basis is whatever I paid for that asset.
Okay.
So if I buy something for $10 and I give it to you, now it's almost as if you paid $10 for that asset. And then if you go around and sell it for $30, now you have a capital gain of $20. So you're going to pay tax on the $20. All right. Now if I die and give you that same asset as an asset under my estate, you get it when it's worth $30. So if you sell it at $30, you don't pay any capital gains tax on it.
Ah, I see.
Okay? So there's oftentimes a determination as to whether it's better to die owning an asset and pay the inheritance tax on it, say 4.5%, to get the stepped up value
I
so
see.
that then you can go and sell it, because otherwise you're going to pay 20% capital gains.
Got it.
So there's a lot of, you need to think things through.
Yeah, trade off on what you
Right.
can trade off which taxes by how you hold
Right,
it.
and
That's
it depends on the value of the asset, if it's appreciating or depreciating, the needs of the people involved. There's definitely not a one-size-fits-all solution, because if an asset's at its peak and the person that owns it hasn't died yet,
Yeah.
and they want to give it to somebody else, then you have to do a lifetime transfer. and you have the capital gains to deal with.
Yeah.
So there are various factors that go into making that decision.
Okay.
And that's why it's important to understand the interplay between the death taxes and the income taxes and the different relationships between the parties and the tax rates and what your options are.
Okay. Perfect. Well, I see we're out of time. I appreciate all of you tuning in. Tammy, I appreciate your being here again.
Sure. Good to be here.
And we'll be back again next week.
Securities and investment advisory services offered through SagePoint Financial Inc., member FINRA SIPC, and registered investment advisor. Insurance services offered through Driscoll Insurance and Financial Services Inc., which is not affiliated with SagePoint Financial Inc.